hypothetical where we were trying to take that out of the mix. And the reason why ACARA is different is because ACARA didn't just simply say no prostitution in bookstores. That's what your hypothetical effectively says. It says no data security problems in speakers or in this particular speaker. And I think that that would trigger, at the very least, intermediate scrutiny.
All right. Thank you. Thank you.
Justice Sotomayor?
That goes to my question, which is Justice, the Chief Justice asked you whether or not we've ever had a case where pure ownership was at issue and not speech. And I don't think we've had one like that. You're right. But I don't think that your the question gets to the essence of your argument, is it? The essence of your argument is you're being asked to divest because of speech, correct?
Correct.
All right. So if I get past that, if I go to Justice Alito's point, which is I don't think it's just about speech, it's about data control. Mm-hmm. If it's about data control, and assume, for the sake of argument, that I believe intermediate scrutiny applies to the data control provision, then your arguments would be different, wouldn't they? They would be under inclusiveness, they would be other arguments, correct?
Well, Your Honor, I think they'd be very similar because I think the nature of our arguments work just as well under intermediate and strict scrutiny. If I could unpack that a little
No, I'm not going to,
Sure.
because we're going to run out of time, because we're going to need to figure out what intermediate scrutiny means. But I'm not sure it means what you do, which is I don't think any of our cases have ever suggested that we have to use the least restricted means under intermediate scrutiny. In fact, our cases have said we have to use a reasonable means.
And if I could respond to that point specifically, I completely agree it's not a least restrictive means alternative, Your Honor. But you do have to at least consider alternatives. Here, if the concern, let's take the data security concern, which you put your finger on.
I know you want to keep going on, but I can't let you, because I can't monopolize the argument, okay? But let me just get to the bottom of that, all right? You seem to suggest that Congress has to actually look at all of the alternatives and say no. I don't think we have a case that says that.
I am not
If from the record it's clear that alternatives won't be adequate for whatever set of reasons, isn't that enough?
If the record were clear on that, that might be enough.
Now
but
I
here
take that.
on
Now
the
let me
key,
go to the next question and the last.
If I could, Your Honor, just one sentence. If on the key less restrictive alternatives, they had actually considered them and said what you suggested, this would be a different case. But our point is that on the key, most obvious, less restrictive alternatives, a law, for example, that simply prohibits TikTok Incorporated from sharing any sensitive user data with ByteDance or anyone else, there's nothing in the record that suggests they even considered it. And that's why it would fail under even intermediate scrutiny.
We have a different problem, which is that the record shows that there is no sharing that could happen that wouldn't put the data at security. But we can go past that.
That's incorrect, actually.
No, because the NSA doesn't.
I'm not talking about the NSA.
Or even anything else. But putting that aside, one last question. Assuming that the covert manipulation issue is one, I think that what remains is, to the Chief's question and Justice Alito's questions, if the covert manipulation is a concern, then the question becomes what kind of burden does it put on TikTok USA? And I think your point is that that requires strict scrutiny because it doesn't permit them to speak to the Chinese government through the algorithm and promote whatever speech it wants to promote through the algorithm, correct?
It doesn't permit them to speak to the American public through the algorithm.
Right.
And promote whatever type of speech they want to promote on the algorithm. And I also think that this covert manipulation is a little bit odd. They're not concerned just with covertness. If all you were concerned
I'm going to
with
ask
was secret.
Xi about that. How do you disentangle the two things?
Thank you, Your Honor.
Justice Kate? Justice Gorsuch? Justice Kavanaugh?
Just on the data collection interest, I think Congress and the President were concerned that China was accessing information about millions of Americans, tens of millions of Americans, including teenagers, people in their 20s, that they would use that information over time to develop spies, to turn people, to blackmail people, people who a generation from now will be working in the FBI or the CIA or in the State Department. Is that not a realistic assessment by Congress and the President of the risks here?
Well, Your Honor, I'm not disputing the risks. I'm disputing the means that they have chosen. One way, the most direct way to address that, all of this user data sits on data servers in Virginia controlled by Oracle. I'm not talking about the National Security Agreement. What I'm talking about is a law that simply says to TikTok Incorporated and its U.S. employees, you cannot share that user data with anybody. You can't give it to ByteDance. You can't give it to China. You can't give it to Google. You can't give it to Amazon. You cannot give it to anybody under threat of massive penalties. They never even considered that most obvious alternative. And so whether you apply intermediate scrutiny or strict scrutiny, it's not a least restrictive means test, but you got to at least consider the most obvious alternative.
So you acknowledge the risk that Congress and the President were concerned about. You're just saying the means they chose to address that risk were incorrect,
so
not permissible.
I certainly acknowledge the risk, but I think there are lots of reasons, not just the one I just gave, but there are lots of reasons why that risk still can't justify the law. When it sits alongside of the impermissible covert manipulation risk, I think it falls under Mount Healthy. It's no different if they came in and said, we passed this law, one for data security.
I understand that, but just on the data collection, that seems like a huge concern for the future of the country.
And Your Honor, again, it is a concern, two responses. First, it is a concern that can be addressed directly. The reason why there's no evidence in this record about whether that kind of direct prohibition on TikTok Incorporated from sharing sensitive user data with anybody, including ByteDance, the reason why the record is devoid of any evidence of that is because Congress never considered the other side of the balance. And that's the minimum that Congress has to do under the First Amendment. It's got to at least consider the consequences of shutting down a speech platform used by 170 million Americans against the benefits of an alternative, like simply saying to TikTok's employees, you're essentially going to get massive fines, potentially jail sentences, if you share any of that sensitive user data with anybody. Not TikTok, not ByteDance, not China, not anybody else in the world. Yet there's nothing in this record that suggests they even considered that alternative.
What happens after January 19th if you lose this case? Can you just spell that out?
At least as I understand it, we go dark. Essentially, the platform shuts down.
Unless there's a divestiture.
Unless there's a divestiture, unless President Trump exercises his authority to extend it by night. But he can't do that on January 19th. On January 19th, we still have President Biden. And on January 19th, as I understand it, we shut down. It is possible that come January 20th, 21st, 22nd, we might be in a different world. Again, that's one of the reasons why I think it makes perfect sense to issue a preliminary injunction here and simply buy everybody a little breathing space. This is an enormously...
What do you mean by shut down, too? Can you just spell that out?
So...
if you
the app is not available in the app stores. That's at a minimum. But in addition, what the Act says is that all of the other types of service providers can't provide service either. Now, there's enormous consequences for violating that for the service providers. So essentially, what they're going to say is that, I think, we're not going to be providing the services necessary to have you see it. So it's essentially going to stop operating. I think that's the consequence of this law, which again is why a short reprieve here would make all the sense in the world. It's an enormously consequential decision, and I think all would benefit if it weren't necessary.
Thank you.
Justice Barrett?
So I just want to, it's kind of following up on Justice Kavanaugh's questions. Let's say I agree with you that some level of scrutiny applies, and I'm trying to figure out which level of scrutiny applies, and I'm trying to figure out if there's content discrimination. And let me ask you a different question than I did before about the algorithm. I mean, you keep saying shut down. The law doesn't say TikTok has to shut down. It says ByteDance has to divest. If ByteDance divested TikTok, we wouldn't be here, right? If ByteDance was willing to let you go and willing to let you take the source code with you, that would be fine, right? We would not be here.
Well, Your Honor, if ByteDance divested, then the law wouldn't fall on TikTok. But the law, not ByteDance.
But that's because of ByteDance's choice, right? I mean, this is like Justice Kagan's point. I mean, I'm trying to figure out how we account for the reality of third-party choices and the choices of third parties that the whole reason for the law being passed in the first place.
Yeah, Your Honor, I still don't, I think that the way the analysis works is step one, is there a First Amendment violation?
Right.
Step two, you get to the question that we're grappling with. What standard of scrutiny do you apply? Typically, what you do is you ask, is this law content-based? Is it content-based based on its face? Is it content-based in its decision? Here, we know it's content-based on its face because it says what it says. We know it's content-based in its motivation because the government concedes it's content-based in its motivation.
Well, that's not quite what I'm asking. I mean, let's see, that's the dispute between you and the government. Is it content-based if it's about divestiture and not about telling TikTok what content it can display on the platform?
And I think it has to be because I think that really goes to the first question. Does the burden fall on the speaker? If the burden falls on the speaker, that triggers the speaker's First Amendment rights. But the law is, in fact, content-based, whether it comes in the form of a divestiture or something else. When the law specifically says it's content-based, we're worried about the content on the platform. And when the government tells you that one of our reasons, one of the things that we're worried about is TikTok, not ByteDance, but TikTok Incorporated and TikTok in the United States will, absent the divestiture, have a mix of content that we find objectionable. They will mix around their videos in a way that is too pro-Chinese or too anti-American,
Okay,
and that is TikTok, the platform.
Let me just ask you one last question. Why is it impossible to divest in the 270 days, even assuming that the Chinese government hadn't said you couldn't?
Sure, and this is the exchange I was having with Justice Gorsuch. There are two basic reasons. The first is that the underlying source code, that's the source code that comes in here and then has to be converted.
But that's what Justice Gorsuch said, just not ever. So it's not really that you can't do it within the time frame. It's that you really couldn't ever divest because you never are going to get the source code.
So, well, let me unpack that a little bit. No, it's that with the underlying source code, it takes a team of engineers to update and maintain that. It would take us many years to reconstruct a brand new team of engineers to do that with respect to the source code. With respect to the sharing of content, that was the different reason. In theory, we could kind of send our salesmen around the world, go to Ireland, go to Finland, go to every country and say, look, you used to automatically get our content, but now you got to separately sign up for our platform.
Last point, let me make sure I understand what you're saying. It's not that you couldn't execute the disentanglement. You could say, we're independent. You just can't recreate TikTok in any kind of way.
Well, I think that any new TikTok would be a fundamentally different platform with different content, which is yet another reason why I think this is a content-based restriction that falls directly on TikTok Incorporated itself in our platform.
Justice Jackson?
So I guess I'm back to some of the questions that Justice Barrett and Justice Kagan asked about the sort of threshold issue that you point out, which is there a burden on the speaker? I'm trying to understand what the burden is that you are articulating and whether it really isn't about association and not speech. You say you have in your brief some cases that talk about American speakers being free to choose whether to affiliate with foreign organizations, and the colloquy you had with Justice Kagan made me think that what you're really complaining about is the inability to associate with ByteDance and its algorithm. That it's not really about, if TikTok came up with its own algorithm or bought an algorithm from some other company or devised it or whatever, this law would have nothing to do with them from your perspective. But the problem I think you're articulating, and this is, I'm seeking your clarification.
Sure.
The problem I think you're articulating is that you want to use ByteDance's algorithm and therefore associate with ByteDance, and Congress has prohibited that by requiring divestiture. So isn't this really a right of association case under the First Amendment?
I think it's both, Your Honor. I do think that that is a component of it. We want to use the algorithm that we think reflects the best mix of content. That's the algorithm that reflects the best mix of content. What this law says is we can't do that unless ByteDance exercises a qualified divestiture. But I also think more directly what this law does is it says to TikTok Incorporated, if ByteDance doesn't exercise a qualified divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says that, though. I mean, if TikTok were to post-divestiture or whatever, pre-divestiture, come up with its own algorithm, right, then when the divestiture happened, it could still operate. It doesn't say TikTok, you can't speak.
I think that's theoretically correct, Your Honor, but I think that also underscores the content-based nature of the restriction.
No, but the fact that that's true suggests that you're wrong about the statute being read as saying TikTok, you have to go mute. Because TikTok can continue to operate on its own algorithm, on its own terms, as long as it's not associated with ByteDance. So isn't this really just all about association?
Your Honor, I think it is partly about association, but I'm going to take another shot at explaining why it's not just about association.
Okay, well, let me just take you down the association path for a second, because if it is about the association of TikTok with ByteDance, then don't we have cases that seem to undermine your view that Congress can't do this? I mean, I thought we had cases about Congress prohibiting association with terrorist organizations, prohibiting association with foreign adversaries, and so why doesn't this fall into that kind of group of our jurisprudence?
Well, at least as I understand all of those cases, they applied strict scrutiny. The material support statute most definitely applied
and ultimately upheld the law, so fine.
But sure, and I think if we go down the strict scrutiny road here, I don't see that this law can possibly be satisfied under the interests that they assert here. But I do want to emphasize why this is also about TikTok speech. Even under your hypothetical, where theoretically they can say something differently than they are saying today, that in and of itself is a direct restriction on TikTok speech. They can't engage in the speech they want to engage in. They have to engage in a different kind of speech, the speech they don't want to engage in. That is a direct burden on TikTok Incorporated speech.
All right, I think I understand that argument. Let me ask you a question about your colloquy with Justice Kavanaugh. Did I understand you to concede that there is a compelling interest and that the problem is really tailoring? I mean, you said, I understand the risks. I don't hear you suggesting that the risks don't exist. So it sounds like we've gotten past, even if we're in strict scrutiny world, we've gotten past the compelling interest part of this.
No, Your Honor. What I was saying is that all you had standing alone were the data security. That would be a different case. Here, when you have the content manipulation sitting right alongside of the data security, that taints the data security rationale. If Congress came in and said, we're passing this law for two reasons. One, we really care about data security, and two, we hate the speech on TikTok. The data security wouldn't alone sustain that law. Under cases like Mount Pleasant,
I understand, but why you're equating we don't want foreign adversaries to be able to manipulate the content on this platform. You're equating that with we hate the content, and I'm just trying to understand why. Because
content manipulation is by definition a content-based distinction. Look, everybody manipulates content. There are lots of people who think CNN, Fox News, the Wall Street Journal, the New York Times are manipulating their content. That is core protected speech. That's why they put so much weight on this mere covertness.
Right, but that analysis is just about content-based versus content-neutral, and therefore whether you apply strict scrutiny. I'm in the strict scrutiny world, okay? I'm assuming that you're right, that strict scrutiny applies, and now prong number one in that world is, does the government have a compelling interest? And so I'm trying to understand why the government's argument that we have data manipulation concerns, which I understood you in colloquy with Justice Kavanaugh to say is a risk, and we are concerned, based on what Justice Gorsuch says when he's looking at the facts, that the government contends that there's this real problem with this foreign adversary doing manipulation in other places. Are you saying those are not compelling government interests?
I am 100% saying that content manipulation is not just not a compelling governmental interest, it is an impermissible governmental interest. You could not go to CNN or Fox News and say, we're going to regulate you because you're manipulating the content in the way that we don't like. That is per se impermissible.
Okay,
That
can I
is
just
why-
ask you one last thing? You say, with respect to the tailoring issue, that disclosure, you think, is a possible, more narrowly tailored way of handling some of this. And I guess I'm just wondering whether disclosure under this court's case law and the law of other lower courts doesn't carry its own First Amendment complications. That wouldn't we have compelled speech problems if disclosure was required in this situation?
Sure, Your Honor. Now, look, I might think so because I think that the factual predicate is wrong, but they think the factual predicate is right. And if the factual predicate is right, then there are no First Amendment problems at all under Zauder and the cases that you're suggesting. And that underscores the larger problem here. Not all disclosures are perfect. I'm not here to argue that they are. But you've always got to consider what the alternative is. And here the alternative is shutting down one of the largest speech platforms in America. The reason there's no evidence in this record as to disclosures is because Congress never even undertook that balancing in the first place.
Thank you.
The bare minimum that has to be done before we take an unprecedented step of shutting down the voices of 170 million Americans.
Thank you.
Thank you, counsel. Mr. Fisher?
Mr. Chief Justice, and may it please the Court, wholly apart from the company's legal interests here, the Act directly restricts the First Amendment rights of American creators to participate and speak in what the Court a little less than a decade ago called the modern public square, and what you might say today is the most vibrant speech forum in the United States of America. And the Act, therefore, is inescapably subject to strict scrutiny because of the First Amendment implications. And the Act fails that test, and indeed any level of scrutiny under this Court's case law, because the Act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with its implication and its use of the phrase national security in this context. But that just simply doesn't change the calculus. Throughout our history, we have faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow doubt about our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the Court should reverse, and I would welcome the Court's questions.
How exactly are the creators' speech being impeded?
So two ways, Justice Thomas. First, I just point you to the text of the statute, which directly regulates text, images, real-time communications, videos. My clients, the creators, are the ones creating that speech and posting it to speak to other
But
Americans.
it doesn't say anything about creators or people who use the site. It's only concerned about the ownership and the concerns that data will be manipulated or there will be other national security problems with someone who's not a citizen of this country or a company that's not here.
So there's two ways, and I think the Sorrell case is where you look for the analysis of the First Amendment burden here. As I said, the text of the statute regulates our speech, and then you point out ownership, and this was talked about a lot in the first part of the argument here, so let me be very clear. The American creators have a right to work with the publisher of their choice. So imagine somebody wanted to work on post speech on Twitter, now known as X, and Congress passed a law saying, we don't like the current owner of X. The current owner of X has to sell that platform or else it has to shut down. People who post on that platform and who indeed some of them make a living commentating, engaging on current events, news, politics, would have a First Amendment claim to work with that particular
using that
publisher.
argument, you could have said that about the breakup of AT&T. You could say that about the foreign limitations on foreign ownership of broadcast companies.
Well, no, I think that you have to dig a little deeper than that, Justice Thomas. It's not mere foreign ownership, and it's certainly the broadcast cases I'll get to in a moment, but it's foreign ownership because of a particular perspective. If you boil it down to an essence, the owner of a print media or online media publication is the essence of the viewpoint of that publication. The current owner of X or the current owner of Fox News or the current owner of MSNBC has a particular perspective, and working with that particular platform is shot through with the ownership from top to bottom.
But why couldn't Congress prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States? I mean, I thought that's what Holder versus Humanitarian Law Project allowed. So I don't really understand what you mean.
Right, so I'm glad you're bringing that up.
Yes.
So when it comes to this national security, you are right that Congress can prohibit Americans, to use that case as an example, from associating with terrorist organizations or other organizations that pose a clear and present danger to this country. This case, Justice Jackson, is fundamentally different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine U.S. leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, and this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, and I think the place I would point you most directly would be the opinions of Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't understand how that's distinguishable from what's happening in Holder. So can you just say a little bit more?
It goes to the nature of the national security threat. So my position is the government just doesn't get to come in and say national security in the case is over, or you don't get to associate. You have to dig underneath what is the national security claim. And what Justice Holmes said in his Abrams dissent, and I know that was a dissent, these are hard issues, but that has been vindicated over time, is that it's not enough to say national security. You have to say, what is the real harm? Is it terrorism? Is it where our battleships are located?
Justice Kavanaugh presented a number of potential risks, right, with foreign adversaries using covert manipulation of the data platforms that are being used by youths today that would then make it more likely that people would turn into spies and do terrible things to the United States. This is a hypothetical, but you know what I'm saying?
I get it. So I think if I understood Justice Kavanaugh correctly, he was talking about the data security argument. So let me just pull these apart. You first have an argument, and the government itself separates these two arguments in its brief. The first argument, the one I'm focusing on initially, is the content manipulation argument. And that argument is that our national security is implicated if the content on TikTok is anti-democracy, undermines trust in our leaders. They use various phrases like that in their brief. So my primary submission is that is an impermissible government interest that taints the entire act. Now there's a secondary argument the government makes, and we say you don't even get to that because once you have an impermissible motive like that, the law is unconstitutional. But even if you could get to that, Justice Jackson, I do grant that data security and the way Justice Kavanaugh spelled it out is compelling. That is compelling, but that's not the question. You just don't ask in the air, was Congress worried about data security or could it reasonably be worried about data security? You say, can this act, the act before you, be sustained on data security grounds? And our answer to that has to be no. You don't have to look any further than the divestiture provision itself, which says that the content recommendation algorithm cannot be used in the future. Well, that has nothing to do with data security. So the core feature of the divestiture provision is going at content manipulation, which I said is impermissible. You can't uphold that under data security grounds. And the rest of the act, when you look at the covered companies provision, Justice Jackson, if this were primarily a data security law, what you think you'd find is what kind of data is procured? How is it stored? Is it shared? Those are the things you think you'd find under covered companies, but you don't find that. What you find is, are text images shared? Is content being shared between users? Is it being created and posted in a social media platform? So I don't dispute for 1 second that data security is a very important thing, and Congress in this very law regulated data security in other ways with data brokers. That's perfectly permissible. But the question before you today was narrower. The question is this law before you sustainable on data security grounds? And that answer has to be no.
Congress doesn't care about what's on TikTok. They don't care about the expression. That's shown by the remedy. They're not saying TikTok has to stop. They're saying that the Chinese have to stop controlling TikTok. So it's not a direct burden on the expression at all. Congress is fine with the expression. They're not fine with a foreign adversary, as they've determined it is, gathering all this information about the 170 million people who use TikTok.
Well, again, Mr. Chief Justice, if I may, let me separate where you started, which was the content manipulation, and then go to the data security part of it. So,
well, the first part was not. I'm not talking about the content manipulation. I'm talking about the content harvesting.
When you say content harvesting, do you mean people's data?
They've got
or
all the information, whatever algorithms they want, that has access to the personal information, or at least information that is not readily available, about 170 million Americans. And whether they're going to use it in 10 or 15 years, when those people grow up and have different jobs in different places, or whether they're going to use it now. That, at least as I look at the congressional record, is what Congress was concerned about.
Well, I think
and they're not concerned about the fact that it is available. As I said, the remedy is just somebody else has to run TikTok. So they're not concerned about the content. They're concerned about what the foreign adversary is doing.
So if I may, I think to answer your question properly, I think I have to separate two things. One is the content recommendation algorithm. And that's what I was speaking about a moment ago. That has nothing to do with data security. That doesn't itself procure data. That just determines what videos people see on their feed on TikTok. As to that, I think the answer is inescapably that the government and Congress itself was worried about content. The government itself is here saying national security. So like a mix of cat videos or dance videos doesn't affect national security. No matter what happens, the only thing that can affect national security are the substance of those videos. And when the government's pressed in its briefing, it outright tells you that. It says what we're really worried about is sowing doubts about U.S. leaders, et cetera. So let me turn then to data security. Yes, there were various congresspersons, and in the record that we have in the D.C. Circuit, there were conversation about the problem of data security here. As I said, I don't dispute that that is a valid governmental interest. So I think you addressed whether that alone can sustain the act in two steps. First, you would ask, if you have an impermissible motive and a permissible one, can we sustain the act based on the based simply on the permissible motive? And I think for the reasons Mr. Francisco said, and we lay out in our brief, that alone, the answer is no under Hunter against Underwood and other cases. Even if you could get just to the data security question, again, you'd have to ask the question, would this law have been passed by Congress for data security reasons? Because you're being asked to uphold a law based on that single governmental interest. And when you look through the provisions, like the content recommendation algorithm provision, like the covered company provisions, the answer is no. And if you're still in doubt on that, just go back to the under-inclusiveness problem. Would a Congress really worried about these very dramatic risks leave out an e-commerce site like Temu that has 70 million Americans using it, and every bit the connection?
Does Congress have to go all or nothing on that? I mean,
it doesn't have to go all or nothing.
They isolate a particular problem, and they might be getting to what you're talking about next. Who knows? But you're really sitting up there and saying Congress would not pass the divestiture law if data security were the only interest.
So I'm saying it would not have passed this divestiture law if data security were the only interest. It's very curious why you just single out TikTok alone and not other companies with tens of millions of people having their own data taken, in the process of engaging with those websites, and equally, if not more, available to Chinese control. So I'm not trying to say that Congress has to do everything at once. I'm trying to say that once you've concluded that content manipulation, for the reasons I've said, as a matter of our history and tradition, has to be impermissible.
Is there another site like this one that covers half the American population?
I don't think, just by way of sheer numbers, Justice Sotomayor, that the answer has to be no. But 70 million seems like a lot.
170 million is a lot, but put that aside and then go to the next question, which is, how many of these sites have all of the data collection mechanisms that TikTok has? From what I understand from the briefs, not only is it getting your information, it's asking, and most people give it permission, to access your contact list, whether that contact list has permitted them to or not. So they can now have data about all of your contacts and anything you say about them. How many other sites gather information by keystrokes to be able to do voice and finger ID information if they choose? And there's a whole lot of data stuff that was discussed in the brief that I don't think any other website gathers. So wouldn't this be a unique site? If I viewed the evidence that way, how would this be under-inclusive?
Justice Sotomayor, I don't think a lot of the suppositions you're making actually bear out. And as Justice Gorsuch was pointing out, one of the obviously the real challenges in this case is it comes to you without an ordinary trial record compiled and all the rest. So we have only limited amounts of information. But absolutely, these other websites are taking much the same kind of information, if not more. And as to the contact list thing, I think that points out one other aspect of this. That is a voluntary decision by an American user to share that information. In the Riley case—
But not informed. And
well,
even if informed—
that could be solved. If you don't think it's informed, that could be solved by a warning or disclosure.
No, they can't be, because for the United States, the threat of using that information is what is at issue. It's not whether the user thinks it's okay. It's whether the U.S. believes that it could put sites at issue. But let me ask you one last question and fundamental question. Assuming that content-neutral data collection concerns were is one of Congress's provisions, divest because of this. Why can't we separate that out from how we analyze the algorithm question? And couldn't we sever the two provisions to say divestiture is right, but you can't force them not to discuss algorithm?
Well, I think the reason why you can't do that was Mr. Francisco explained. I'd direct you to a case like Hunter against Underwood and just analogize it to this situation. If what you had is the government saying, we are shutting down TikTok or requiring divestiture for two reasons. One, because we think it helps the Democratic Party too much. And number two, because we're concerned about data. I think that first interest would be a poison pill. That would be an impermissible, or because we think there's too much pro-Catholic content on TikTok. I think there are some interests that are just so constitutionally verboten that I think that just makes the act unconstitutional, and you can't go looking for other interests. You send it back to Congress. Look, if you want to pass a data security law free and clear of this impermissible interest, you go ahead and do it.
So,
can I say one other thing, Justice Sotomayor, just because I think it is also telling here that even if you didn't buy that poison pill argument and you just asked whether Congress would have passed this law, something else that I think you might notice is even if all this act goes into effect and the law goes through, TikTok gets to keep all the data. So wouldn't a data security law require them to expunge that data or get rid of it or something? I mean, it's a very weird law if you're just looking at it through a data security lens, and maybe Congress could do better.
Mr. Fisher, often we require divestiture for antitrust reasons, for example. And as I take it, your argument here, and we don't think of those as normally implicating the First Amendment interests of users or people who might speak or associate with editors. And the difference here is, as I understand it in your mind, that this law is motivated by a content-based interest. Is that a fair summary?
I think that, and the only thing I would add to it is just the prior step, which it is regulating the speech itself for content-based reasons.
Yeah, yes. We don't do that in the antitrust area, but
exactly.
You say this law does. Okay.
Exactly.
And it does on the covert content manipulation side. Do you think that's a compelling interest or not? Forget about the tailoring for a moment.
No, my point is that preventing content manipulation, whether it's covert or not,
is simply not
impermissible
compelling.
if what you mean by content manipulation are the kinds of interests the government is saying, like undermining trust in our leaders, undermining trust in democracy. That's Whitney and Abrams, and like those cases.
I got it.
Yeah.
I got it.
So,
just a couple more. I'm sorry. I'll finish up real quick. And so that would take us to the tailoring question, and there you say disclosure and alerting Americans that there is covert content manipulation possibility, putting aside the data collection part of it. telling Americans that there is covert content manipulation going on in TikTok, or at least it's possible. And the government says that's just simply not enough. And the D.C. Circuit did too, and I wanted to give you a chance to respond to that.
Right, so I think that's the only aspect of the governmental interest that could be permissible, the covert part. And my answer, as you just said, is disclosure solves that problem. And you have a law, a long-standing law, which we haven't talked about yet today, that gives you that example. Again, under a history and tradition test, you look at not just precedent, but laws and traditions of our country. Look at the Foreign Agent Registration Act, passed in the run-up to World War II, and the concern was Americans would be controlled by foreign agents to speak and advocate certain causes.
We didn't ban them.
You did not ban them. All you did is require, Congress, all Congress did was require disclosure.
Certainly wasn't. I wasn't around for that. On the secret evidence point, I'm concerned about the government's attempt to lodge